Jerry Mahun began his career as a surveying instructor in 1979, retiring for a second time in 2020. Jerry has taught at the University of Wisconsin-Platteville, Purdue University, Penn State, Wilkes-Barre, and in the Madison area technical college, presented workshops and seminars since 1984. Jerry has worked with the NGS, BLM, Wisconsin DOT, and the Wisconsin Department of Registration and Licensing, and has also done some consulting. Jerry, although retired, Jerry still occasionally presents seminars such as tonight, and probably for Wisconsin, I'm sure, and serves on a few of the Wisconsin land survey committees. Jerry was licensed in Wisconsin in 1984. And so we thank Jerry for your time and presenting tonight on the rules of construction. So thank you for coming and joining us again tonight.
All right, glad to do it. Let's see, get my screen shared here. Share. Okay, got it?
You are good. Yes, sir.
Excuse me. If I'm not looking, I don't know if you can see my face or not, but if it appears I'm not looking at you, is because I got multiple screens here. The camera's kind of offset to the side and that type of thing. But again, my name is Jerry Mahun, and at my website, jerrymahun.com, is where I've posted the material for tonight's presentation. And I will also be posting the answer keys for the answer key for the assignment. If we don't get a chance to go through that tonight, it'll be there also. There were some typos in the original PowerPoint that I put up. No matter how many times you go through it, there's always spelling errors and stuff in it. So what I did is I corrected it, and I uploaded a corrected version and found some more errors afterwards and that type of thing. So I'll try to point those out as we go through the stuff tonight. By the way, this triangulation station, Jerry, was set in 1983 by yours truly. So I do have an NGS control point named after me. It's in Dane County, Wisconsin. So that's one of my legacies.
Nice.
It's interesting when you find information about surveying boundary issues and that type of thing. I came across this article in the newspaper about 20 years ago, and I thought it was really interesting. 5 women, this is from Bangladesh, 5 women armed with heavy spice grinders and iron rods surprised a sleeping man and beat him to death over a land dispute. The women aged 18 to 45 attacked the man in his hut near Dhaka late Wednesday, and he died a few hours later. Their family had been engaged in a long-standing dispute with a man over about half an acre of land. So you can see that some people take this real seriously. So surveying is one of those things that can help resolve some of these problems, hopefully. Learning objectives, learning objectives for tonight real quickly. We will start with how boundaries and parcels are created, where the rules of construction come from, what are unwritten rights, how gaps and overlaps are handled with adjacent properties, this concept of the statute of frauds, why that matters, and some description interpretation issues, ambiguities, controlling informative terms, and written intent conflicts. And in the paper that I wrote for this, I peppered it with a lot of examples from actual deeds and descriptions that have been recorded in Wisconsin. Once I started doing this at workshops, showing these things, people started sending them in from all over the place. And it's really interesting, some of the issues that surveyors have to try to deal with. Now, one of the things that you have to remember about what we're going to be talking about tonight is that a 40-slide PowerPoint isn't going to make you a description interpretation expert. That comes from experience and learning more as you go through the actual boundary reestablishment process. This is just a general overview with a lot of caveats because it's based on common law, which can vary between jurisdictions. So you have to be familiar with the common law in the area that you're going to be practicing, because something that's generally stated in textbooks or presentations may not be applicable in that context in your particular area of practice. So you need to kind of do a little bit of research on the common law side of things. And a lot of times there's no definitive solution to reestablishment problem. You'll find that the evidence doesn't always point to a concrete solution. And at best, what you can come up with is, based on all the information that we've got and the way we've evaluated, this is our best guess or our best estimation as to where the boundary should be or where the corner should be. And you'll see that the examples that I use tend to be simplistic. And that's primarily because if you change the evidence a little bit or the situation a little bit, it can dramatically affect the conclusion that you're going to reach based on that. One of the things I miss about doing in-person types of presentations, particularly when I was doing them at school, was the tangents you could go off on when you started talking about a particular situation. Somebody say, well, what if this were the case, or if this happened? Then you start talking about those types of things. And you have to remember to consider all reasonable alternatives and why they do or don't apply to a particular situation. The last thing you want to do is be caught as providing testimony in a court case and have the attorney for the other side say, well, did you consider this situation? And for you to say, no, I didn't. You want to be able to sure it's got all your bases covered. Now, with that in light, I always bring my legal counsel with me to whenever I do presentations like this. Everybody see this? See what this is? Magic 8-ball. You know, I did a presentation for a bunch of real property listers and attorneys, and I whipped this out of my briefcase at the beginning. I said, this is my primary legal reference. And the real title people laughed. The lawyers kind of looked at each other and didn't know what to say. So, but I wouldn't be surprised if some of them don't have a magic 8-ball on their desks today. So, but that does come in handy. All right. In order to understand the rules of construction and some of the things inside of it, the conflicting title elements, we got to know something about where boundaries come from, how they're created, because that identifies the relationship between adjacent properties. And we refer to parent and child relationships in the creation of boundaries, where the parent is the original parcel from which smaller parcels are created, children. And whenever a child is created, at least one new boundary is created. So in the case of like this example down here at the bottom, let me go to my laser pointer. Down here, this parcel right, this child A created off this parent, it's got two new boundaries, but it also shares boundaries with the parent. Now, the parent-child relationship, the human relationship, is a good one to use with respect to property conveyance or property creation, because a child inherits characteristics from the parent. So whatever the relationship that the parent has along these boundaries here, because the child shares those boundaries, the child inherits those relationships. And also in a lot of contexts, and we're not going to get into this too much tonight, but sometimes when you get into a quasi-meets and bounds description and you don't know how the line is supposed to be run, generally courts say that the child should be created so as to mimic the parent as far as configuration goes. So a child-parent relationship, and the other thing to keep in mind is the parent has to always provide for the child. So if this guy conveys to this person 10 acres, this person has to have 10 acres to convey to that person. So those of you with children can understand this. You know, you always have to take care, you have to be subservient to the children. So multiple children create multiple new boundaries, and depending on how those children are created and what sequence will define the dependency of the boundaries with respect to each other. So we'll talk about that as we go through this, Mank. Now, the process in creating those boundaries, how they're created affects a couple of things. The type of description that's used for those properties, as well as how gaps and overlaps are handled or excess or deficiencies. The boundary creation, you got to remember that once a boundary is created, that boundary exists forever, right? Unless it's removed by some legal process. It can't just go away of its own accord. And it creates the adjoiner relationship with the piece that's next to it, or everything that surrounds it that touches that boundary. The location is considered without error. It's one of the fundamental premises in land surveying is wherever the original boundary was created, or wherever the original monument was set, right or wrong, that's where it belongs unless it encroaches upon a higher right. And we'll see examples of that a little bit later on. And then it creates the evidence framework for later reestablishment. In Wisconsin, our public land survey started back in the 1830s. There's very few of the original monuments that are left from those old surveys. There are replacement monuments, there are fences, there are roads. This is all the evidence that's built up based on these original corner locations. So that initial framework was created by that boundary creation. Now, there's basically three methodologies to create a boundary: simultaneous, sequential, and combination. And in most textbooks, and Brown's textbook, for example, they refer to these as conveyances, which is kind of a misnomer because a conveyance is when you convey rights, when you sell the property from one person to another. So it could be a whole series of conveyances associated with a property. What we're basically talking about is the initial conveyance that creates new boundaries. Once those boundaries are created, remember, they're established once and forever. So I'm just going to talk about them as creation method. I was not going to refer to them as conveyances per se, because conveyance in my context is going to mean when rights go from one party to another. Okay. Page down. The simultaneous conveyance is the boundaries are all created at the same time by the same legal instrument. And all the boundaries that are created have equal standing with respect to each other. There's no junior and senior rights. And an example of this, for those of you in public land survey states, is the creation of sections. When a township plat is recorded, accepted for recording, at that point then 36 sections, or however many are within that township, are created at once, and they're all equal standing with respect to each other. When a section is quartered, those quarters are created simultaneously by connecting opposite quarter corners. That's a simultaneous conveyance, and so on and so forth. So aliquot parts are all simultaneously created. In most states, subdivision requirements require that when the map is accepted, at that time it has to be surveyed and all the monuments have to be placed. So when it's recorded or accepted for recording, at that point, then all those parcels are created at the same time and are in equal standing with respect to each other. And that's generally a lot and block type of description. So lot number 1, the Sweetwater addition. So you can see that a simultaneous conveyance, there are no junior and senior rights between the children that are created, and the description is typically a lot and block or an aliquot part. Okay, so to a certain extent, when you look at a description, it kind of implies a type of conveyance. So if I say I've got the northeast quarter of section 16, that implies a simultaneous creation of that quarter section. Okay. Sequential is parcels are created independently from the same parent over time. And the earlier created boundaries have higher precedence, or they're senior over later created ones. So if I got my parent parcel here, and in that process, we create parcel 1 in 2008, then parcel 2 in 2010, and parcel 3 in 2015, there's a hierarchy or precedence of these boundaries here. Parcel 1, because it's first, is senior to everything that follows it. Parcel 2 is junior to parcel 1, but it's senior to parcel 3. Okay. So we see that we've got that dependency of boundaries. So there are junior and senior rights in there. And a typical type of descriptions that we have for sequentially created parcels are a meets description, or a bounds description, or a meets and bounds description. The difference between the two is meets means by measure. So we generally give directions and distances. Bounds means by limits, like we call for joiners or call for a river or call for a road. Meets and bounds combines those two together. That's what most people are familiar with. So again, if you see a meets and bounds description, that implies that that parcel was sequentially created. Now that's not 100% true all the time, but it's the initial implication. You won't know unless you do a title search. The last one is a combination conveyance. It's called a combination conveyance because it's a combination of sequential and simultaneous. And generally what it is a sequential creation of a simultaneously created parcel. So the boundaries can have characteristics of either or both. There may or may not be junior and senior rights. And there may, the description uses kind of combinations of the lot and block description and a meets and bounds description. For instance, if we've had a 6-lot subdivision here, and instead of conveying the entire lot 5 or the entire lot number 4, a new parcel is created, new boundaries are created here to create this piece that's part of lot 4 and part of lot 5. So we've sequentially created a new parcel from a simultaneously created set of parcels. And the new parcel is part of lot 4 and part of lot 5. And the description is called a quasi meets and bounds description, or sometimes referred to as an of description, because it's something of something else, part of lot number 4 and part of lot number 5. So it'll have characteristics of both a meets and bounds and a lot and block type of description. Right? Now, the rules of construction themselves is an evaluation framework of evidence. And it's presented in list form, although I tend to not put numbers or letters on it because I don't want to imply that it's a hard and fast set of rules. But there's basically just 3 areas that the rules of construction cover. The first is the right of possession. The second is the senior right. And the third is written intentions of the parties. So these top 2 are basically based on particular circumstance. What's the situation with respect to on the ground actions that have happened between adjacent parties? The one below the line, this is the description that you find on the deed. Okay? And within that, the hierarchy is call for survey, call for monuments or adjoiner, distance and direction, area coordinates. And we'll step through each one of these tonight, talking generically about them. But basically, it gives us a way to weight evidence when we've got things that conflict out there. Now, it's not strict. They're guidelines. They're developed from common law. So again, things can change. The description wording, and we'll see how just a change in nuance of how the words appear in the description can alter the way we evaluate the evidence as far as conflicting evidence is concerned. If we have all these elements present in a description, but physically we start to lose them, which happens over time with evidence, then what can happen is lower elements can take the place of higher elements. Okay, so again, it's one of those weighting type of thing. If we don't have this, even though it's identified, then the next best thing is this. If we don't have that, then the next best thing is this. Now, again, we'll talk about extrinsic evidence later on, because again, that can come into play also. We'll see how external evidence can help or hinder interpreting a description. All right, the first one, right of possession, unwritten rights, is at the very top. It's based on adjacent owner action and inactions, and there's a spelling error there I missed. Ownership departs from the description, and you'll see some text talk about possession lines, title lines, deed lines, and all this kind of thing. And the deed line is basically what's described in the description. The use line or the possession line is where people are acting with respect to and exercising ownership, whether they actually have it to that or not. And there are a couple of different doctrines that unwritten rights can mature under. And one is adverse possession. The other is prescription, oral agreement, equitable estoppel, and recognition and acquiescence. And I believe Knut Hermansen is going to be doing 2 presentations a little bit later, one on adverse possession and the other on prescription, which is a special kind of adverse possession.
That is correct.
But ultimately what happens is the ownership is determined by the courts. The surveyor doesn't have the authority to determine if somebody has gained ownership by unwritten means. So for instance, in this case here, where this fence is encroaching on this owner here, and this person is using continuously up to this one here, it has to meet particular requirements and that type of thing. He in fact may have ownership rights to here, but the surveyor doesn't make that determination. The court makes that determination. The surveyor at best shows where is the deed line and where's the possession line. And the court may use that possession line or that use line to determine what is the extent of that unwritten right. Now, if it does mature so that this is an unwritten right, that this person gains this by, say, adverse possession, it does not change the deed. The deed line is still here. And for all intents and purposes, unless the court orders a reformation of the titles or rewriting of the descriptions, this description will forever describe this line here. This description here will forever describe this line here. So again, that's kind of an iffy area for surveyors to get involved with. They can identify that something exists of that case, but they don't make the decision with respect to it. Now, in some states, adverse possession in particular is codified. In Wisconsin, we have 3 different time periods that are statutorily defined for adverse possession to mature: 7, 10, and 20 years. And we have adverse possession, government entity protections against adverse possession, I think, right in our state statutes. Not all states have that. You might want to check that in your particular state to see if that's codified under it, so you at least get an idea of what the elements are required for adverse possession to occur in your particular state. We also have prescriptive easements that are defined statutorily, as well as within, with respect to common law. Senior right in case of a gap or overlap. Now, remember, the precedent is established when the boundaries are created. So once a boundary is created, the junior and senior right is established and doesn't change until the boundary is legally removed. You got to remember that the junior and senior relationship is a boundary attribute. It's not an owner attribute. If somebody is the senior owner of a parcel and then sells that to another person, that second person then becomes a senior owner again, because that senior junior relationship sticks with the land. It doesn't go with the owner, that type of thing. So you got to think again in terms of what is the precedence of the boundaries with respect to each other. Remember that the child inherits parents, junior and senior standing along shared boundaries. And so right here, I've got a relationship that's inherited from the parent. And here, the junior and senior relationship is established based on when these 2 parcels are created with respect to each other. And the other thing to remember is because the parent has to provide for the child, the parent is junior to both of the children. So whatever's left over of the parent parcel has to provide is junior to these individual children that are created off of it. So whenever you have 2 or more children that are adjoining created from the same common parent, you've got a potential for a gap or overlap. And the resolution depends on how the parcels are created. If it's simultaneously created, remember the individual created boundaries within a simultaneously created situation like a subdivision, there are no junior and senior rights associated with it. So any excess or deficiency between found original monuments or found original corners is apportioned into the lots that are affected by it. So in this case here, if I've got a corner here and a corner here, these 2 are found and these 2 are not. Remember, a monument or a corner is wherever the surveyor located it, placed it unless it infringes upon a higher right. And then the distance between these 2 is 372.5 instead of 375. So they each get shorted a proportional amount of that total distance. So it adds up to 372.5. So in a subdivision, it's proportion between the found corners. In a public land survey system, the same thing is done using single or double proportionate, depending on which kind of corner you're reestablishing. If you're reestablishing a quarter corner, then you're using single proportionate measurement. If you're reestablishing a section corner on an interior corner, then you're using double proportionate measurement. So again, depending on the hierarchy of the lines as they intersect in a public land survey system, you're going to be using single or double proportionate measurement, which you're basically doing the same thing here as we're doing here. In a sequentially created one, things can get pretty interesting. Earlier created boundaries have higher standing than later boundaries, so they get precedence. So again, if this child is created off the parent, the child parcel A is senior to the remainder of the parent. Later on, when parcel B is created, it's junior to parcel A, but senior to the remainder of the parent. And when the final part goes off, This is the most junior parcel. This is the most senior parcel, and this is the one that's intermediate. Now, if we take that relationship that we have, and then we create another parcel here, parcel D, off of the A, which makes this the remainder of A. This is the parents now for this child, and it shares boundaries with that parent. It inherits the junior and senior relationship with it. So even though it was created 7 years after this one, it is senior to the 2010 parcel, okay? And this is one of those cases where if you see a meets and bounds description that calls for a parcel or calls for an adjoiner, does that mean that that adjoiner is automatically senior to the parcel, the instant parcel, because it had to exist before the description was written? No, and this is a situation where that happens. Is this may call for parcel B in the description, but parcel B is junior to parcel A, so parcel A's boundary would limit where parcel B is, and because parcel D shares parcel A, it's senior to it. See that? How do you find that out? How do you know that this is in fact senior to this one, even though it's 7 years older, 7 years newer? What do you have to do? That's where you jump in, audience participation. What do you have to do?
Look for chain of title.
Yeah, you got to do a title search back to when these parcels were created. And sometimes you have to go all the way back to the original parent parcel to see what the creation process was that led to that. So you don't want to go just back to when this parcel was created, but you also want to be sure that you understand what the adjoiner relationship is with respect to this. Now, why go all the way back to the parent? Because the parent has got potentially junior and senior relationship along the southern boundary here with the adjoiner to the south. Okay, so if that's the case, this guy here has got that same junior and senior relationship with respect to the parcel to the south. So you got to go back far enough to establish when these boundaries were created in order to understand what the junior and senior relationships were. Again, there was a typo down here. It's this parcel D is senior by inheritance. I originally had parcel B in there, which is a mistake. So be sure you correct that. All right, along junior senior boundaries, what happens is the senior parcel is protected in the case of an overlap. The junior parcel yields. It can't get what is allocated to the senior parcel. If there's an excess, a gap is created. And this is one that people tend to kind of get tripped up on. The gap is a parent remainder. The tendency is to say, well, if there's a gap, if there's a little bit left over, we'll give it to the senior parcel because there is a senior parcel. Or we'll split it between the two. No. What happens is a gap is created that was never conveyed. So in this case here, if I've got a gap here, you don't automatically give that to the senior owner to the junior owner. It is still a remainder of the parent parcel. Now the court may decide, well, we'll give that to the senior owner, or the court may decide we'll split that between the two. But that's a judicial decision based on the lack of on a defect in the title. What we're bound to do is to define the deed lines on here where they fall. And we might say, well, look, the original surveyor, the original owner didn't intend to create a sliver there like that. So they evidently intended to get rid of, divest himself of all that property. Well, we have a case in Wisconsin. I'm sure there are other cases in a lot of states that are similar to this. Is the question is not what reasonable men intended to convey, but what they in fact described in the contract or the memorandum. So whatever they said they were conveying, that's what was actually conveyed, as long as it doesn't infringe on a senior right. So a gap is created, and that's the remainder of the parent. Now, if that happened 30 years ago, chances are one or the other has been using it and has gotten it by adverse possession or some other means like that. Again, that's not the surveyor's purview to decide that. That's a court decision. Okay. So our job is to be sure that we identify where those deed lines are. Now, combination conveyance, a combination conveyance, without I'm getting all tongue-tied here, the parcel boundaries may or may not have junior and senior relationships, okay? So an example, we start with our 3 lots in the subdivision here. And we create over time, sequentially, the west 100 feet of lots 12, and then later the east 100 feet of lots 12. Remember, the record dimension here is 200 feet on the north and 200 feet on the south. So the presumption is there's 200 feet to work with there on both sides. So when that is created, this is the parcel. This blue and this green together is that parcel that's created. Along this line here and this line here, there are no junior and senior right because they inherit those from the original lot number 12. That's the parent parcel. Here, however, we do have a junior and senior right situation because this is created first. It is senior to this one that's created here. Simply pretty straightforward. Well, let's say that on a resurvey, there's 198 feet between these 2 found monuments here and 202 feet down here. Make them drastically big so we can see the numbers. What happens is along the north line, because this is the senior owner, this one gets the 100 feet that they're given because they're senior. And the junior owner has to yield and they only get 98 feet. Along the south, the senior owner gets his 100 feet. The junior owner gets her 100 feet, and there's a 2-foot remainder in between. So we've got this little sliver that was never conveyed. Now, how can we avoid that? Well, one way that we can avoid that is to not do this kind of stuff. But another way to avoid it is to, instead of using calls from 2 directions, whenever you use calls from both directions, and you're giving specified dimensions or areas, you got run the potential of having a conflict later on if the dimensions don't match what the presumption is. One way to do it is to use a description by exception. So in this case here, we changed the wording a little bit. We make it the west 100 feet of lot 12. That's the same as it was before. But then for the other one, we convey lot 12 except the west 100 feet. Got that? So we just changed it a little bit. Instead of saying the east 100 feet, we'll say, well, it's what's left over of lot 12 after the west 100 feet is gone. Once you do that, then on a resurvey, this still has got the 98 feet here because the 100 feet is given here. But down here now, that 2-foot gap isn't created. The 2 feet goes onto this one because after we mark off the 100 feet for the senior owner, whatever's left over goes to the junior owner. And that way there's no creation of a gap in that situation. So just by changing the wording a little bit in a description, it can drastically change how we interpret who gets what in a junior senior right situation. Okay, whoops. Wrong one. Okay. All right. So now let's, so we looked at unwritten rights and we looked at senior right in the case of an overlap for the most part. And then we kind of dropped down to the one that's below there, that's written intent. So when we talk about written intent, we had call for survey, call for monuments, and all that kind of stuff in there. Why is that even in there? Well, the reason that's in there is because the statute of frauds, which goes all the way back to 13th century England. And it's a law that said basically the contracts had to be in writing in order to be valid and enforceable. And every state pretty much has some form of the statute of frauds and contract law. And it will tell you in your statutes what elements are necessary to be present for a contract. Sort of like it has to identify what's being conveyed from one party to another, that there's good and valuable. You ever see a deed that's got on it for $1 another good and valuable consideration? Those are legal terms to show that there was something that was exchanged for the property. Otherwise, it's a gift. And if it's a gift, that's different than a deed or a contract type of thing. But the reason that we had the contracts written that way is that all the terms for the transaction between the parties are included in that document, so that later on, it prevents either party, either by word or by action, contradicting what was actually conveyed between them. And also, it provides interested third parties the opportunity to look at that contract and understand what was the transaction between the two parties, particularly if they're going to be a third party to that transaction. In property conveyance, the deed is our contract for property conveyance. If you look at it, it's got the elements of a contract. It identifies the buyer, the seller, the description, where it is, the valuable exchange between the two and all this, and it's delivered. A deed in most jurisdictions, again, you'll have to check your particular jurisdiction, but like in Wisconsin, a deed does not have to be recorded to be legal and valid. It only has to be delivered to the purchaser. Once that happens, a conveyance takes place. But the description defines the physical extent and the rights that are transferred. It identifies if there's anything that's being withheld or given to that property, like easement or removal of mineral rights or given additional rights to a well or that type of thing, ingress and egress. But that's what we refer to as a written intent. Everything about the conveyance is boiled down to those words. And the courts generally look at a description as if it was sufficiently accurate for the conveyance to take place in the first place, nothing can act to make it invalid later on. Now, and how many states do they actually check the validity of a description to see if it closes and all the elements are there? Okay, I can't see you raising your hands, but I doubt very many hands go up at all. Okay, the only place that really happens is in a torrents title system. And we've got a couple of those scattered around this country, but for the most part, we have a passive deed recordation system. That is, when a deed gets recorded, they only check to make sure that there is a description there. Not necessarily that that description is valid or that it closes to 1 in 10,000 or anything like that. It's just that there's a description that's there. And as long as it satisfies the grantor and the grantee, as far as the courts are concerned, that's sufficient, which opens up all sorts of problems for us as surveyors later on, because who can write a description that goes on a deed? Audience participation, jump in. Who can write one?
Surveyor.
Yeah, a lawyer, anybody. In Wisconsin, anybody can write a description. It doesn't have to be a lawyer. It doesn't have to be a title person. It doesn't have to be a surveyor. Anyone can write a description that goes on a deed. And not understanding the nuances of the rules of construction is why you get things like slivers that are created because the calls don't match and that type of thing. And again, I got examples scattered throughout the handout of those things. We'll see some of them here. Now, what about unwritten rights? Say, well, if a conveyance has to be in writing to be valid, well, then how the heck can somebody gain ownership of land through unwritten rights? Well, the courts don't view unwritten rights as a conveyance. They view that as a way for adjacent owners to come up with a solution to an uncertain boundary between them two. Again, Knut will go into this in more in depth, but they look at it as the parties are making something certain that was uncertain before. And they just assume that the parties make that decision, then make a big deal out of it, that type of thing. So a title, unwritten rights is not a title transfer, but a title clarification. All right. Now, when we're doing the description interpretation, generally the problem isn't with simultaneous conveyances because a map or a plat is involved, and that's the result of a survey that was performed by a surveyor. Okay? And it has to meet specific statutory requirements as far as monumentation goes, labeling, areas, all that kind of stuff. That map, because it's referred to in the description, becomes a part of the description. So all the information that's on it, unless it's a fraudulent survey of some sort, that generally doesn't cause too much of a problem with interpretation. Where we run into problems with interpretation, and we have to start looking at this order of importance of conflicting title elements, is when we're dealing with narrative descriptions. That is, descriptions that are written in terms of words. If you look at a typical meets and bounds description, it's one big long sentence, commencing at, and then containing X number of acres, more or less, at the end. It's one big long sentence with semicolons separating the independent clauses, which are the individual courses and that type of thing. So it's a narrative. And anytime you put a narrative together and combine a bunch of elements, you're giving a lot of opportunity for those things to conflict. And to compound that is we have two really big things that affect interpreting descriptions. One is archaic terms or ancient measurements that are just propagated. The description is never updated. So they just take the description that existed for the property as is and use it for the next one, and so on and so forth. Again, without benefit of survey for the most part. So you can see this is 1992. This is point of commencement, commencing at a point 20 rods, 19 links north of a point that's 26 links east of the east side of the steel tube at the northeast corner of the wagon bridge. This is in downtown Belleville, Wisconsin, which is really high real estate prices. And this is a very expensive piece of property. And there is no wagon bridge left anymore, let alone a steel tube and that type of thing. But if you look at it, is this a contemporary description? No. When's the last time you wrote a description that used rods and links? The only agency that's still doing everything in terms of rods and links is who? The Bureau of Land Management with respect to the cadastral surveys and that type of thing, because that's required by USC. Or if it's written by non-surveyors, because non-surveyors, don't understand necessarily how to assemble the words so that there's no ambiguities involved, but they also sometimes misinterpret things. Commencing at the west quarter of section line, thence north 80 degrees, 29 feet, 17 inches east, 2,781.62 feet, thence north, south. What happened here? What happened here? They saw the single apostrophe and thought that meant what? Feet. They saw the double apostrophe, thought that meant inches. So they just interpret it in that fashion right there. And the whole description, this is 1996, this is recorded. So the whole description is written in this fashion here. Now, a surveyor looks at that and go, well, I know exactly what happened. Other people looked at it, it looks perfectly fine to them. Okay? So again, written by non-surveyors. Now, that thing, as far as the courts are concerned, is sufficient to convey the property. It's up to you as a surveyor now to locate this thing on the ground. Okay? I've got descriptions that use paces for distances. How long is a pace? It depends, right? So ultimately, all this stuff here means the surveyor's got to follow the common law principles to interpret the description. If the surveyor writes the description, the surveyor should follow common law principles to create that description. So it's kind of what goes around comes around type of thing. But the problem is we have so many people, including attorneys, who don't understand the nuances of surveying that are putting together descriptions that really don't make sense. So we get this concept of controlling and informative terms. Because when we talk about the rules of construction and the order, the implied order, the importance of that type of stuff, again, how we word it can have an effect on if we have to flip those orders around and that type of thing. But controlling term is something that determines a course termination and or its path. And basically identifies a condition or multiple conditions. And we look for keywords like to, along, parallel, perpendicular, with, continuing. They imply something specific. An informative term is everything else in a course description that helps to identify that controlling term. If we say that's north 38 degrees west, 139.6 feet to an iron stake, we see the word to in there. The intent was to go to an iron stake. As a matter of fact, iron is informative. It's to a stake that's iron, that's at this bearing and at this distance. So this is the controlling term in here. So we look for that. If we've got then southwesterly along said high water mark to an iron stake, we have two controlling terms in there. Where the line ends, the iron stake, and how the course goes when it goes to that iron stake. It goes along the high water marks. It's called for a topographical. So it's not in a straight line. It's along whatever that adjoiner is, it's called. So those are controlling terms and informative terms. If we have something like to an iron stake in the north line of Jones, and Jones is the senior owner, what's the controlling term? Is it Jones property or is it the iron stake? Well, it's the iron stake and Jones property is the informative term, but if it's inside of Jones property and Jones is senior, Then we start to run into dilemmas with respect to stuff like that. So again, the informative and controlling terms kind of give us an idea of what order, or if we need to change the order of the rules of construction when we look at the different elements that conflict. Now, we get into ambiguity. And ambiguity is basically anything that can be reasonably interpreted more than one way, and it introduces confusion. We don't know what they meant. So, and that's common in descriptions written by non-surveyors. If we go back to that description that had degrees, feet, and inches in it, that's confusing initially because we see that there's something that's wrong there. Okay? So extrinsic evidence is physical and parole evidence from outside the description. It's something that's not contained in the description itself, but it's something that can help us explain the terms of the description. We can't change the terms of the description. We can only explain them based on that. For instance, if we go back to that wagon bridge, chances are if you try to find that wagon bridge today, it's going to be gone. You're not going to be able to find that wagon bridge. So what do you do to find that wagon bridge? Well, you got to look for other evidence that leads to tell you where that wagon bridge may have been. If there's somebody that's old enough that remembers the wagon bridge, then you have some parole evidence you could potentially use. If there's some other surveys or plans that were tied to that wagon bridge, you might be able to reconstruct its position from that information right there. So the idea is not, you're not going to change it from a wagon bridge. It's still a wagon bridge. We just are trying to reconstruct where that wagon bridge was based on that external evidence. Okay. So two different types of ambiguities. There's a latent ambiguity. A latent means it's hidden. It's not apparent until application. That is, on the face of it, the description looks okay. There's no confusion in the terms until we try to apply those terms out in the field. So my missing wagon bridge, on the paper, it looks okay. But when I go out in the field and I can't find that wagon bridge, then I've got a latent ambiguity. I can't find it because I tried to apply it out in the field and it's not there. So here's one, commencing at a point 84¼ degrees east of the center of section 7, being station A, having bearing tree viz, a black oak 14 inches in diameter, so on and so forth. So first of all, commencing at a point 84¼ degrees east of the center of section, what exactly does 84 degrees 1¼ degrees east of the center of section mean? Is that north 84¼ east or 84¼ off the center quarter line? But it doesn't give you a distance to point A. The only way that you can establish point A is by going to a black oak and that Stephen Taylor dwelling house. And chances are really good, 14-inch black oak from when this was written may no longer exist. So you have to reconstruct the location of that black oak in order to find out where point A was, where the commencement point was. So again, on paper, it looks okay, but it's not until you try to apply it out in the field that you run into an ambiguity. It's confusion. A patent ambiguity is obvious. It's immediately apparent. In that example I gave before of the feet and inches in the bearing, it's apparent what the error is. So it's a mistake in the original contract, and the mistake must be found and applied where it occurred. And in most cases, in most jurisdictions in Wisconsin, we can file something that's called a correction instrument. And a correction instrument identifies, well, a correction instrument can be used for a lot of things, but in the context of the deed, we identify the deed and we identify the error in the deed and we put that correction in there and we record it. When you do that, that correction instrument becomes part of the chain of title. So if the next person that is investigating this property and they encounter this description, there's a correction instrument that's on file that shows what the error was and how it was applied. So again, depending on the jurisdiction, you may or may not have that type of document, or it might be called something else. But when you identify that error, you want to include it as part of the chain of title. But we don't change the bearing. Well, what they meant for a bearing was, no, we only find that error that's in there and apply that error where it occurred. Now, so in written intent, after taking all that into account, as we step through all those different levels of written intent, the very top one we have is call for survey. And some boundary creations are based on survey and monumentation. For instance, the U.S. Public Land Survey System, the basic premise of that was survey before sale. So that they would go out there, they would mark these things on the ground, they would identify how much area is included, what the distances are between the section corners and the quarter corners, and then a map was created. And then whenever a sale took place, it took place with respect to that map or with respect to that township plat. So the presumption was that behind that stands an actual survey and actual monumentation that occurred. And that's true for most subdivision plats in most jurisdictions. You have to monument that mapped subdivision before you actually sell it. Okay, so people can start acting with respect to that physical monumentation. So they're the primary evidence of intent. Now, for meets and bounds description, sequentially created parcels or combination conveyance, well, sequentially ones, pure meets and bounds, there's no guarantee that a survey ever took place, okay? Because anybody can write that. With a sequential, a combination conveyance, theoretically, it's a sequential of a simultaneous, so at least there's an underlying subdivision plat that goes on, that's underneath that. So at least there's some information that's implied from a measurement monumentation perspective. But the new boundaries that are created aren't necessarily based on a survey. So monuments and corners. Now, we use these terms interchangeably, sort of like accuracy and precision, but a monument and a corner is not the same thing. A corner is a legal location. It's where a line, a boundary line changes direction. And it's dimensionless. And it has, the only attribute it has is location. A monument is a physical feature that we use as evidence to mark a corner. We like monuments because that's what we can set up on over what our toll stations or GPS receivers or whatever. What we want to know is not necessarily where the monument is, but where the corner is. If the monument can be proven to be there because of the corner, then we use the monument as a surrogate for the corner. If the monument controls, and that's another thing, is just because we find a monument doesn't mean that monument necessarily has authority. And it goes back to the description again. Now, a monument, in order to control lesser elements, in order to have authority, has to meet three requirements. And I see another typo already. This is description, it should be. It must be called in a description, it must be unidentifiable, and it must be undisturbed. Now, when it's called in the description, if it's written in as part of the description, that shows that the intent was there to act with respect to that monument. It has to be identifiable, that we can look at and feel, say, yep, that's the monument they referred to, and it has to be undisturbed. Okay, if we find a monument, but it's laying on its side over here, that's a disturbed monument. We can't use that to give it authority. Now, what about replacement monuments? Well, a lot of original monuments in the public land survey system were wooden posts. They no longer exist. They've been replaced over time with stone, concrete, aluminum, metal posts, and that type of thing. So we have replacement monuments. Well, in order to accept a replacement monument, in order for it to have authority, there has to be some documentation that shows that this monument actually is a replacement for the corner that was there. So if it calls for a 4-inch post, wooden post, but we come out there and we find 1.5-inch iron pipe, is that iron pipe connected to that post location? If we can't find a connection between those two, then it's not called for. We don't have it directly connected to that original monument. Now, a monument, if it controls, can control two different ways. It can either control direction and termination of a line, or it can control direction only. The termination is controlled by a higher element. And an example of that is a closing corner. And you're all familiar with closing corners, the public land survey system. They were intended to be placed on a township boundary, right? Where a section line closed on a township boundary to the north, and in some cases to the west. We have closing corners on the west and north in some townships in Wisconsin. The premise is that it was intended to be on the township boundary, but it could be long or short of the township boundary. Where the actual corner location is where that quarter line intersects the township boundary. Where it intersects the township boundary is as it passes through the section, the closing corner. The closing corner controls only the direction, but not termination. So it can, depending on the particular situation, it can either control both direction termination or direction only. An accessory is something that's placed at the same time as the original monument was and is measured with respect to that monument. And those are considered a part of the monument. So when we had that point A called before, and it was identified with that 10-inch oak, that 10-inch oak becomes an accessory and it becomes part of the monument for that corner. How many of you have ever run into monument nests or pin cushions like this? Okay. So every this is to me, this is a survey's equivalent of a dog peeing on a tree, saying that this is my location right here because it's that much better than this guy's right over here. You know, so a lot of interesting stories behind those types of things, I'm sure. Now, the monument disposition is this location certainty. And we use the BLM, the Public Land Survey definition for existing obliterated and lost corners. And that pretty much fits most of the situations we deal with in land surveying in general, boundary surveying in general. An existent or found corner is a position that can be identified by the original monument or its accessories or acceptable physical and parole evidence. We're pretty certain about the location. We can point at that spot and say, I'm pretty sure that's the original corner location based on the evidence that's available. Obviously, if I have the original monument there, that's the best. But if I've got other things like a replacement monument that's connected to the original monument, I can point at that and say, I'm pretty sure that's an existing or found corner. And obliterated means there's no traces of the original monumentation of the accessories, but the position can be established beyond reasonable doubt using physical and parole evidence. Again, this is stuff that happened after the monument was set or after the corner was set and reflects actions or evidence that are based on that corner location. Things like fence lines and roads and that type of thing. They may not intersect at a real nice distinct point, but we can be pretty sure they're generally in this area right here. Within reasonable doubt, it's located in this area here. A lost corner is, there's not enough evidence to establish it by found or obliterated methods, or the evidence is so weak or so contradictory that we can't really say, well, this is where I think it is. It's because if I look at it this way, it might be over here. If I look at it this way, it might be over. It's just weak. It's too contradictory. In a case like that, you have to resort to measurements surrounding the corners. We may have to go back and use things like proportionate measurement to reestablish the lost corner in that particular case. So those are the disposition. That's the character of the corner that we're looking for. Now, we'll see sometimes people are saying that we accept the corner by common report. And anytime you see the word common law what? Common law property. That has to deal with court decisions and tribunal decisions, which means that those are going to vary from jurisdiction to jurisdiction. But basically, by common report, the justification is that I can't find a whole lot of stuff, but the corner that everybody's been using, like this corner post here on the fence, it's in a reasonable location with respect to the corner that we're looking for. All the people around it accept it as their corner. They've just been using it. They've acquiesced in that position. And I really can't disprove that location. I can't come up with better evidence that says there's a better location for this corner. So I'll accept it by common report, okay? You shouldn't do that because common report means that there's some unwritten rights happening here. If you look at reasonable location accepted by all affected parties, that's just like adverse possession. It's how people are acting with respect to a boundary. And because that's the way they act, that's an unwritten right. That's not necessarily something that you can point at and say, I know that with unreasonable doubt that that's the corner location. You want to be able to accept or reject a corner location based on the evidence that's collected. So you might use parole evidence in the case of these people here, or parole evidence of people in that area that may have information about that, or other survey records that may tie to that point. How many know what beating the bounds means? Anybody know what beating the bounds is? This is a practice I think we should bring back to this country here. It comes from England. And it used to be that when one owner conveyed property to another owner, they physically walked the exterior of the property, and the grantor would touch the corners, say at this tree or at this rock, and would point out to the grantee what was being conveyed. Now, that was just between those two. To make it more cemented in the local tradition at that, so people would know outside of that, outside of those two people where the corners were, they would sometimes take along a 7 or 8 year old boy with them. And when they would touch the corner, say, this rock right here, they'd beat the living crap out of the kid. Like that, right? And then they'd move to the next corner and do the same thing, beat the crap out of the kid. Say, that's child abuse. No, it's embedding a memory. Right? If you think back to when you were a kid, and you got a beating from your parents, never got a beating from your parents. If you close your eyes and think about that right now, you can remember everything about what was going on during that time. You remember exactly what you were wearing, where you were standing, who was doing what, whether it was sunny outside, rainy outside, or whatever. You have an embedded memory based on physical alteration. So that's what they would do. They would beat the crap out of a kid. And then 60 years later, when I was a senior citizen, you could take him around. If he started shaking when he got near a corner, you knew that was a spot right there. That's where I got it, that type of thing. So it may be something we should consider bringing back into this country, is beating the bounds. They still do that in England, but only strictly as a showmanship thing. They don't actually beat anybody with respect to it. But it's one of the things to consider. Distance and direction. Below the monuments. Oh, was that a question? Distance and direction is the next element. It's inferior to controlling a monument, but they can control if the monuments are not called. There is no call for a monument. Or if there is a monument that's called, but it's lost, we have to resort to using distance and direction to locate that corner. Now, the problem with this is a direction basis has to be recreated in the field. What did they use for direction? When I taught writing legal descriptions in my classes, I always stressed that in the summation, always include what the basis was for the direction. Directions are all based on the east line of said quarter section, which is assumed to bear due north. That way we knew what the basis was, or based on the Dane County coordinate grid system, give a basis. In most descriptions, you don't see that in there. On plats, on certified survey maps, minor subdivision maps, and that type of thing. Even on the old USPLS township maps, you saw a basis for direction. They would show where true north was and where magnetic north was and what the declination was for the center of the plant and that type of thing. But if it's not shown, how do you recreate it in the field? Well, obviously the best way to do it is find 2 adjacent corners, original corners, and use that as a basis to start with, but it's tough. Distances, when I was in Pennsylvania, I found out that, and I'm trying to think what the year was, prior to 1820, if somebody's from Pennsylvania on here, maybe you can tell me, but I think it was prior to 1820 or so, any distances that were given were assumed to be along the ground, not horizontal distances. After 1820, they were assumed to be horizontal distances. So again, based on local practice and that type of thing, there are different, how those distances are measured. As a matter of fact, I believe in Philadelphia, they had a slightly different definition for the foot than they had everywhere else and that type of thing. So again, you run into some problems like that with some of the older descriptions. Also, how the numbers are written convey 2 things. They convey magnitude and implied accuracy. If we've got a call that says north 200 feet, how close to north do we have to be, let alone which north is it? We have to be within a degree, within half a minute, within 20 seconds. How accurate do we have to be? If we knew something about when the description was originally written, we could maybe come up with an answer for that. But in order to do that, again, we have to do a title search all the way back to see when that description first appeared. If the distance is only 200 feet, is that good to the nearest 100 feet, the nearest 10 feet, or the nearest 1 foot? If you find a monument at 175 feet, Does that conflict with the 200-foot call? Well, if that 200 feet is only good to the nearest 100 feet, no, it doesn't conflict at all. It's within the uncertainty of that distance. So you got to be careful with interpreting that kind of stuff as to what do they mean by that. Now, that doesn't mean we're perfect today, not by a long shot. I have an example there of a description that was recorded in 2002. Thence south, 88 degrees, 16 minutes, 52 seconds west. There's good, to the nearest second. 0.3 feet to the existing line of section 1. Well, like this. Thence south, 18 minutes, 1 second west, 0.01 feet along said east line of section 1. You ever try to measure off 0.01 feet along a particular direction? Where'd this come from? Anybody have any idea where that may have come from?
The porcupine corner.
Well, yeah, probably, yeah. But the bigger problem is this is probably software generated description from measurements. And if it was adjusted, or even if it wasn't, if it was a really good survey, you could have a 1/100th of a foot misclosure. Well, in the software, that 100th of a foot is a 100th of a foot. So if you let write a description, it'll write a description, it'll have a 100th of a foot in it, which makes absolutely no sense. So you aren't even moving off the monument, for goodness sakes. So just because we have more modern technology today doesn't necessarily mean we have better expression of directions and distances. I've seen a lot of maps and plats submitted to the map and plat competition that we have at WSLS every year, where the bearings are given to 1/10 of a second and distances are given to 1,000th of a foot. Those aren't realistic, okay? We go off the deep end with respect to in the other direction, that type of thing. So we gotta be careful, not only just interpreting stuff, but also when we write things. Another thing that comes into play are called general directions. A general direction is not an explicit direction like a bearing is. A general direction is a range of directions, and there's basically 8 of them. There's 4 in the cardinal directions, and then there's 4 in between those. And they end with ERLY. So there's like northerly, southeasterly, northwesterly, and that type of thing. And they cover about a 45-degree range. We use them primarily as informative terms. So we could have a distance and direction to the northerly line of Maple Drive, as opposed to the center line. Thence easterly along said center line, as opposed to westerly along it. It's an informative term that helps us interpret the controlling terms of the description. They should never be used by themselves. Okay, then southeasterly to Mahun River. That's a 45-degree range that you could be within, that type of thing. That's too generic in that type of thing. All right, what constitutes a conflict? We talk about monuments, distance, direction, all this kind of stuff. What constitutes a conflict? Sometimes that's not that easy to figure out. Say the last 2 courses of a description say that's south 1820 west, 283.2 feet to a 1/2-inch iron pin. That's 220 feet back to the point of beginning. So we've got the 3rd course and then the 4th course back to the point of beginning. All the corners have been recovered except the last one before the point of beginning. So we got this corner up in here. Now we're trying to figure out how do we get down to this one and to the point of beginning. So at the bearing and the distance, there's no monument, okay? There's just that location. We do have an iron pin, but it's at a different bearing and a different distance. And these 2 are about 3 feet apart. The distance from here to the point of beginning is about 220 feet. The distance from here to the point of beginning is about 224.52 feet. So the question is do we have conflicts in here? And if we had to make a decision without any extrinsic evidence, which is the one that we would probably select as a corner location? Now, if we look at point B, are the distance and direction of point B too far from the record direction and distance? Is it far enough away that we might be able to say, well, B doesn't appear to fit the other elements, the other 2 elements, very well. If it was just a little bit out, what constitutes a little bit, we would accept B as the controlling corner. But is it too far out in that respect? Well, let's look at where it is with respect to the point of beginning. It's 224 feet away from the beginning, but the call back to the point of beginning says 220 feet. Is the 224 within the uncertainty of that 220 feet? So again, you have to look at all that stuff and how close do the elements have to, how much do they have to differ in order to conflict with each other? In a case like this, and this is again purely made up, there is really insufficient information to make a decision here on this. You have to resort to extrinsic evidence. Is there other physical or parole evidence that we can use to try to resolve which of these two corners is probably the corner that we would use before we go back to the point of beginning? Because you can make an argument either way. You can make an argument either way in this case. All right, area is one of the lowest elements. Whenever we have an area call in the meets and bounds description, this is generally an informative call. But whenever we have like the public land survey township plat that was recorded, and this is section 6 in a township plat in Wisconsin here, they identify the area, the fractional quarters appear the government lots. It shows what the total section area is, and of all the interior sections, it'll show those are 640 acres. Now, are those interior sections exactly 640 acres?
No.
No, the intent is if it was perfect 1 mile square and there wasn't any convergence and no survey errors, then yeah, we'd enclose 640 acres. Those are considered nominal. That's what they use to sell the land by, was based on those areas, but it's understood that there might be more or less area within there. So when we have the area that's shown on a township plat, it's understood that may or may not be true. Those are informative, okay? In subdivision laws, we generally require that the area be included on the map also. Those are also treated as informative terms. They're not really, don't dictate, because we have bearings and distances and calls for monuments on the plant. So those are generally informative in that respect. However, when you get into meets and bounds descriptions, the area is generally in the summation. At the end, so you describe the parcel going all the way around. Then you say said parcel containing 1.5 acres. And then you say when the more or less, they're just to be on the safe side, that type of thing. But it's an informative term. Okay? However, with a quasi meets and bounds description, where we've got a combination conveyance, the area could be the controlling term. The easterly 2 acres of. What's the controlling term? 2 acres, the thing that's at the very bottom of the rules of construction, now suddenly becomes one of the higher elements, because the intent was to have the easterly 2 acres of that thing. So we got to figure out, how do you run in the line that shows the easterly 2 acres? Well, the courts say that whatever you do, it has to contain 2 acres as intended. And generally, the easterly 2 acres of a parcel is going to put in, because it's calling for the easterly side of the parent, the westerly boundary of this is going to be parallel with that guy. That's again to mimic the child and the parent relationship and that type of thing. You can also have it in terms of a proportion, the southeasterly half. So whatever the parent contains, this would be half in the southeasterly corner of that parent. So again, the quantity becomes a controlling term in that context. How about coordinates? Well, coordinates haven't been used too much in descriptions for a variety of reasons. Most places will have state plane coordinate systems defined for them, but those numbers are huge. And we generally don't put huge numbers like that in a description. It takes too much. So we normally don't use descriptions by coordinates. But if they were included, they were generally viewed as informative. As a matter of fact, in Wisconsin, our subdivision law says that when coordinates appear on a subdivision plat, they have to be either state plane coordinates or county coordinates. We have county coordinate systems in the state, and they will be inferior to all the other elements on that subdivision plat. So basically they're saying right out the bat, it's codified, coordinates are at the bottom of the list, okay? But now we're starting to see descriptions like this appear. This is recorded in 2005, and I'm sure there's a lot more since then. Thence northerly 487 feet more or less to GPS waypoint latitude 43.828655, longitude minus 90, 66.1033. Thence northwesterly. You see that it keeps giving a distance with a more or less on it, which means that's approximate. That's an informative term. And the controlling term in each one is GPS waypoint. And that GPS waypoint is defined as this latitude and this longitude. No call for monuments, no directions. The distances are approximate. This is your description, okay? So a lot of questions come in. What are the units on those? What do you think the units on those probably are?
Decimal degrees.
Yeah, decimal degrees it looks like, right? And a negative 90 means what?
West.
Yeah, west longitude, negative 90. So now the question, okay, so you figure out that's decimal degrees. How accurate are those latitude and longitude decimal degrees? Now they're shown to 6 decimal places, which corresponds to, I think, 0.00036 seconds or something like that. It's really small. But is it actually accurate to that level, or is that just what the readout on the GPS receiver gave us, and we just wrote down whatever it was? It's like on our calculator, you get all these decimal places that show a certain number of them are significant, the rest of them are garbage. Okay, I got a little Garmin handheld that's good to probably the nearest 11 meters. That will give me latitude and longitude to 6 decimal places on positions and that type of thing. But I know for certain it's not that. So how accurate are they? And if they were accurate, the other thing we gotta know is what datum or adjustment are they based on? Okay. NAD 27, NAD 83, 86, NAD 83, 07. What is it? Because it's going to make a difference depending on where you are in that type of thing. So we've got starting to see more of these appear. Now, do you think a surveyor wrote this one?
No.
Nah, who wrote it?
Fantasyland.
Some guy with a GPS on his phone, right?
A realtor.
You got a phone app, and he paid all of $1.95 for it, so you know it's good because it's not one of those cheap free apps. It's a $1.95 GPS app that he probably used, put on his phone. He walked all the way around in that type of thing and picked it up that way.
Onyx
I think the datum. Go ahead.
Yeah, go ahead.
Onyx Hunt. I've heard a lot of people discuss this Onyx Hunt app, and
the Onyx people.
Yes. My Onyx Hunt app told me the corner is here.
Right. Yeah.
Well, the datum that they're using is Fantasyland 2021.
That'll all go away once we get our new datum by the NGS here, once they get past their COVID protocols. It's amazing. I work with when I taught here part-time at Platteville, and I found out that some of the water resources guy had some Trimble GPS receivers. They were convinced that those things were good to nearest hundredth of a foot. They're handheld GOXLs and that type of thing. And I finally had to take them by the hand and take them to an actual control point and shoot a couple control points with them and show them that, no, it's not quite that accurate, regardless of what the display tells you and that type of thing. So, I mean, there's a lot of misunderstanding about the accuracy of GPS and that type of thing because it's the black box technology and that type of thing. But again, this is a description that was created. And if you're asked to resurvey this, there's a lot of questions in here because you don't have anything physical to go to, unless you can find some extrinsic evidence to see that more they go into fence corners and that type of thing. So again, you have to move title search back to see if this is a resurvey of an existing boundary and that type of thing. But we are starting to see it happen. So if this happens, then coordinates suddenly become your most important element because they go up to the top of the list. Okay. All right, more or less is one of those phrases that gets tossed around a lot. We generally see it applied in the summation of meets and bounds description when we give an area and just to be on the safe side, toss in more or less. Other words, approximately, plus or minus, the plus or minus sign, about. Those put the reader on notice that in fact, that term is uncertain. There's a certain amount of uncertainty to it, and that can't be a controlling term. Okay. That said, thence running in an easterly and southerly direction along the south and southwesterly on a private road that is used by the grantee here in a distance of about 28 rods thence. So again, we're given a distance, we're given control. We're running along a road and that type of thing, but the distance is indefinite. How far? About 28 rods. That's uncertain. So if you think that's about 28 rods plus or minus a rod, that's plus or minus 16 feet. That's quite a range in that type of thing. So again, in that context, that's not used correctly. Okay? You need extrinsic evidence to resolve those types of things. One of my favorite things I used to do when I was going to school in Madison, and somebody would stop and ask me for directions, and they were confused and they were in a hurry, I'd always say, go to the last stop sign and hang a left. And they generally drive a couple blocks before they think to themselves, well, how do I know I'm at the last stop sign? It's basically the same kind of thing. As you give them, it's an informative term, it's a stop sign. You just don't tell them which one. Okay. All right, let's look at a little bit more detailed one with conflicting outs. This is actually one of the homework on the assignment. We're going to kind of finish up with this as show conflict with written intent. And this is kind of similar to the one we were looking at before, but we throw in a couple of elements. And we begin, this is a point of beginning down here, 1 inch iron bar. We got these two lines. Okay, we're at this guy here. And it says thence south 1845 west 283 feet. Thence back to the point of beginning. This is one of the things you never ever want to do when you write a description is just say thence back to the point of beginning. You want to give closing numbers for it so that you can show that it mathematically closes. Otherwise, all the mathematical errors, whether they exist or not, get thrown into that last line. It causes all sorts of problems. So diagram shows the course situation. Here it is. Again, we have at the bearing in the distance, there's nothing there. We find a monument, a 1/2 inch iron pin at this distance in this direction here. And both of these positions are inside the pole property, and pole is the senior owner. And there's about 2.5 feet distance between these two positions. Now, in the previous one, we had a call for a distance back to the point of beginning that we could use as another piece of evidence to try to resolve which of the two we might accept. Well, in this case here, we don't have that. We just have thence back to the point of beginning. Okay. So we look at this and say, what are the answers? What if there's no extrinsic, no other evidence available, and you had to go with this, what would you accept as the corner position for that third course? This is where everybody jumps in and we get this crowd noise going and there's argument and there's things being thrown back and forth.
Jerry, the first thing I would want to ask is, what would the intent be?
The intent is what's written up there. That's the only evidence that we have. There's no extrinsic evidence.
All right.
Again, we're looking at and interpreting the written intent.
All right, I'm taking a shot here. I would use the monument as the directional and then cut it off at the distance.
At the 283 feet?
Yes.
Okay. So the 283 feet, the pin, if you use that pin there, this is at 282.91. So if you go 283 through the pin, you're further into pole's property.
Use the monument for line and use the bound as the ending point as well as the direction of the closing.
Okay. Any other arguments for or against or whatever?
How long has the line been there? Can they continue with adverse possession and not tell pole until it's too late?
Remember, adverse possession, we don't care.
Okay.
We plug our ears and we go la 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 because that's for the courts to decide. We're trying to reconstruct the deed lines, and we can go up through senior right, but we can't go into unwritten rights. That's something for the court to decide.
Okay, I amend my answer and I will go to post line, just use the monument as a directional base, go to post line and then close it out that way.
Okay. Anybody else?
Well,
Yeah,
I would like to know how that closing line agrees with the last line in the description for bearing and distance also. Because
unfortunately, we don't have that.
We're not going to be able to cross into Pole's property, obviously, right. But it would be nice to have a little better understanding of how we're going to fit with the rest of the world there.
Right. Well, the other two lines, no question on those. And unfortunately, the last line says just then back to the point at the beginning, and it doesn't give us bearing and distance. So again, we can't use that as evidence. Y'all are doing what the trap that surveyors fall into. Okay. Does the monument have authority? In order for the monument to have authority, it has to be what?
Tagged.
Say again?
Called for.
Called for. Is it called for?
Yes.
Oh, no, it is not. No, it is not. You see that? It gets bearing and distance. Then it's back to the point of view. It does not call the monument. Okay. The monument may be there for a reason, but the reason is not reflected in the intent of the description. So because the monument's not called, it doesn't have authority. If it doesn't have authority, then what's the direction of that line going to be?
Bearing.
The bearing, the record bearing. Yeah. And the distance is not going to be 283 feet. What's it going to be?
It's going to be whatever it is.
It's going to be wherever it intersects at Pole's line. Yeah. See that? You got to look at the written intent. You say, well, it's like the other monuments. That's fine. It's like the other monuments, but it's not called for like the other monuments are called for. The other monuments are called for. That reflects intent. This one was not called for. That doesn't reflect intent.
So okay. if they would have been called for a 1/2-inch iron pin on Pole's line, that might have been usable.
Yes, yes. Now see again, if you change the wording just a little bit, then it changes the circumstance tremendously, right? Which is why only surveyors should write descriptions. No lawyers, no title people, nobody else. Everybody should be. It should be against the law for anybody besides the surveyor to write a description, and it should be against the law for a surveyor to write the description until they've had to interpret a bunch of these things like this and figure out what the problem is with descriptions the way they're written. See what I'm getting at?
Jerry, my dog can write a description in Nevada.
Well,
and my cat could probably follow it.
Yeah, well, the dog probably, because they at least have some sense. In Wisconsin, anyone can write a description. Any person can create a deed and have that deed recorded. The only thing they check for is to make sure that there is a description on a property. One of my students talked to me after we got about halfway through the semester in the introductory surveying class and asked if he could ask me about a problem that his father had with a piece of land that he got from his mother. I should have made the PowerPoint for this. And I said, sure, come in sometime, we'll talk about it. Maybe we'll sit down with the description and try to map it and see what it's like. Well, the next thing I knew, his father's there with a bunch of deeds and stuff like this. And he showed me the deed to the property that he bought from his mother, okay? That he wanted to buy before his brothers bought the property and that type of thing. Because it's like infighting and this type of thing. Well, once I mapped it, the description was nowhere near where his property was. It was totally in a different block within a subdivision, somebody else's property. And I said, well, where'd you get this description? So, I don't know, I was digging through my mom's stuff. I ran across a bunch of these deeds and descriptions and stuff. So I just grabbed one and used it. So he wrote a deed off of that stuff and recorded it. So his description is for a totally different piece of property. So now if you're going to be resurveying that, you look at it and say, well, wait a second. What is it I'm resurveying? I'm resurveying somebody else's property because this guy doesn't own this type. Well, it's because he found something in a shoebox and decided to use that as a description. Okay. All right, on this one here, let me go through a short answer. Proceed at the record direction to Pole's line and stop. Mine is not called for, so it can't control. Neither can a 283-foot distance, says that would violate Pole's senior right. Now, you don't stop there. What you want to do is you want to look at every realistic solution that may exist and then toss them out based on some reasoning or evidence and that type of thing. So, this thing about going to the monument, not be a poles line, that's one alternative, but we can't do that because the monument's not called for. Okay. We go to that bearing in the distance and then back to the point to begin. No, we don't go to the bearing and distance back to the point to begin because we violate Pole's property. So again, you want to look at all the alternatives. And when you accept something, accept it because it fits the evidence or the intent as best as possible. May not make you the happiest, but it's the best solution based on the available evidence and that type of thing. Because the last thing I say you want to have happen is the attorney that asks you, did you consider the fact that this monument is not called for in a description, so therefore it can't control? No, I accepted it because it's like all the others. Or worse yet, I accepted it by common report. So again, you want to look at all the alternatives and throw away the ones that don't make sense. Okay, or don't fit the evidence and that type of thing. All right.
There's a couple of things in the chat that kind of go along with this conversation we're having right now. Yeah. There was Trevor talked about, where'd it go? It was up here a couple. What if the title employee wrote the description and let out the monument on that line? And kind of all in those same theories, like Scribner errors. How do you determine what a Scribner error is? And that's deed is exactly the same, and that kind of stuff.
That's where you got to do the title search. In Wisconsin, when we do a resurvey and our minimum standards, it says that you will perform a survey to reconstruct the lines as best possible according to the records of the Register of Deeds. So that means when I have this piece right here, and I look at it, that monument bothers me. That monument, maybe there is if I got to go back a description, and maybe somebody did when they rewrote the description, there was a call for that monument in there, but whoever wrote it dropped it out. If that's the case, that's an error that I can identify, and I can file a correction instrument to bring that monument back in. But I got to be able to say some way to prove that there was an error that was made on it. And if it was a Scribner's error, I identify that, but I have to do that title search. Okay, that's that. You got to go back far enough to establish the stability of those lines. Did I answer that question?
Yeah, I think so. That's perfect. You can go, down that rabbit hole even farther, right? So at that point, the monument holds for line only and still stops at the pole line, and so yeah.
And again, the court, depending on how good an attorney you have versus the attorney that they have, and the follow-up questions and stuff, that can have a big, you have to educate your attorney on this. Yeah. That example that I used with whether a call for an adjoiner is always a senior adjoiner, showing that child parcel, that parcel D. I was actually in a hearing, a disciplinary hearing, and that question came up, says, is a call for an adjoiner a call for a senior owner? And I said, not necessarily. And they said, no, just say yes or no. And I said, but I need to explain, just say yes or no. And I said, no, because it's not necessarily a call for a senior owner. And then the guy on the other side says, well, that flies in everything I've ever learned about boundary law. And my attorney had the opportunity to do a follow-up on that question, allow me to explain, but they didn't. And because they didn't, we lost on that point.
Oh, geez.
So again, we were right, but we weren't able to pursue the point far enough. So again, you gotta, if you do wind up going into a court situation, you gotta be sure that your attorney's got their ducks all in a row and that type of thing. Okay.
So Jerry,
don't assume that they do. There's right. A lot of interesting things that attorneys think. Yeah.
Jerry.
Yeah.
The other thing that we're looking at with this problem is we're making the assumption that the monuments on the pole line are actually on the pole line, and we haven't discussed researching that, and that's, you got to go there too.
Right. Yeah. So again, that's that title search. You got to go back to, and in essence, recreate somebody else's line also. And that's one of the things that people don't necessarily understand about surveyors is it doesn't matter which side of the line hires us, we should come up with the same solution. That's not true for attorneys. The attorney is an advocate for their client.
Yeah.
So with two surveyors going to court and are testifying based on the evidence, for all intents and purposes, they should come up with the same answer. If they're looking at the same evidence and weighing it the same way. Those are big ifs in that case, right?
Yeah. Our obligation to our client is to determine the location of a boundary line. Is the same as our obligation to our client's adjoiner to determine the location of that line.
Right.
And it's always been that way. And if we're doing anything less, we're messing with both clients, both people.
Right. Every boundary affects at least two owners. Every boundary that's out there affects at least two owners, if not more. So yeah, we have an obligation to both sides of that line. Okay, let me go real quick here through okay, we learning objectives. We went through all this stuff relatively quickly. And again, we didn't go into a lot of depth on some of this stuff. And anytime you start discussing legal issues and things, as we saw with this last problem here, if you say, well, what if this, that can change things dramatically. But it's those kind of questions you have to ask yourself when you're doing a boundary resurvey. That bothers me if that monument is there. Somebody put that there. It's there for a reason. The question is it a reason that has an effect on the decision I'm going to make here? But you don't know that until you do the research. Okay, there aren't any questions. The assignment, y'all did the assignment, right? Now everybody's real quiet, right?
That's right.
I was out in the field today doing this stuff today all day.
That's because I said it wasn't going to be graded. Maybe if I had said it was going to be graded, they would have got more turnout, or people wouldn't have shown up for the presentation tonight. Statute of frauds requires that a contract be in writing. We'll go through this real quick. Informative term is something that helps identify the controlling term in a course description. A corner accessory is any physical or natural feature that is measured to at the same time the monument is placed and becomes part of the monument. Extrinsic evidence is evidence that's outside the document, but it does not change the terms of the document, only helps clarify it. An ambiguity is an uncertainty, a term that can be interpreted in multiple ways. Latent means it's hidden. When I was in the military, I spent some time in the military. You kind of missed that on my little bio there. I look terrible in green, by the way. But I found out that the military has their way of doing things. Like when they wanted to something that's not ambiguous, they would say it's disambiguous. Instead of saying clear, they would say disambiguous. That was one of the big things there. All right, true or false? First one, an exterior lot inherits the subdivision boundaries, junior and senior relationship with the adjoining property. True or false? You haven't got your videos on, so I can't see if you're nodding or shaking your head. What's that one?
That one's true.
That's true, because if it shares a boundary with the parent, it inherits the relationship. A gap between a senior and junior parcel is always assigned to the senior parcel.
False.
False. They may get it by unwritten rights, but not by deed description. An ambiguity exists when a deed term can be reasonably interpreted more than one way.
True.
Right. By virtue of his quasi-judicial capacity, a surveyor is able to render a binding decision on adverse possession.
False.
False. Physical evidence can be used to override written terms in a description.
False.
True.
No, that's false. You can't override the written terms in a description. Physical evidence can only be used to clarify written terms in a description. Okay. But if you do have to, like, say, if I have a 1-inch monument instead of a 1/2-inch iron pin, if you can show a connection between that monument and the pin that was there originally, if they're connected, you're not overriding the terms, you're clarifying the terms because it's a accepted replacement monument. So be careful of that kind of stuff. USPS closing corner is an example of a monument that controls line direction, but not necessarily its termination.
True.
True. A call for another property as an adjoiner in a description means that property is senior to the instant parcel.
False.
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 A monument cannot control a corner location if it or the survey establishing it is not called for in the description.
True.
True. If it's not called for, it wasn't intended to be used. USPS township plat is a simultaneous boundary creation.
True.
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 Once legally created, a boundary exists forever until removed by another legal action.
True.
True.
True. True. True.
So I have explanations of all those on the assignments answer key that I'll post. Okay. Let's jump down to question number 2. A corner which there's no remaining traces of the original monument, but whose accessories are intact, is a found, obliterated, lost, or constructed corner.
Lost.
What?
Lost.
Any others?
Obliterated.
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 No, I get it. I always get everybody on this. It's found. Remember, the accessories are part of the original monument. So if the accessories are intact, the original monument is intact. So it's a found corner by definition. What conditions must the monument meet in order to control monument to control corner location?
Has to be called for.
Right. What else? That's
Undisturbed.
one.
Undisturbed.
Undisturbed. What's the third one? Identifiable. Identifiable. Yeah, you realize pretty soon that things happen in threes in surveying. Found, existent, or found, obliterated, lost corners. The 3 conditions for a monument to be accepted. What are the 3 conditions for a monument to be accepted by common report? Well, there's 3 conditions for that. So a lot of things happen in threes in surveying. I'm not sure if that's somehow tied to the Three Stooges or not, but all right, corner mine. A parcel described by meets and bounds was probably created by what kind of conveyance? What kind of process? Combination, condemnation, sequential. Yeah, meets and bounds is probably sequential. Won't know until you actually do what?
So you read the deed?
A title search.
The title search to see how it was created. I've run into situations where people use a subdivision plat that's been recorded, but instead of selling it by lot and block, they sell it by meets and bounds description of the exterior of the lots. Question becomes, is that a sequential or is that a simultaneous conveyance? So that's a nice thing to play with. What's the difference, if any, between the 2 following descriptions? The northeast quarter of section 15 and the northeast 160 acres of section 15.
One's aliquot.
Right? Which
And
one's
the
aliquot?
other-
160
The
acres
first
is a
one.
controlling element.
Right. Yeah, the first one is an aliquot part, so it's a simultaneous conveyance. All 4 quarters are created at the same time. It may or may not contain 160 acres. The other one's a quasi meets and bounds description where the controlling term is 160 acres. Oh, it said must contain 160 acres, not 80 acres. So it's a controlling term. So those are 2 different. The original owner, the original person that's selling it or wrote the description may have thought that they meant the same thing. So he was trying to convey the northeast quarter, but he called it the northeast 160 acres. But that's not what the intent. That's not what the written intent shows. Okay, page down. That's it. Ta-da! Any questions? I finished with 12 minutes left. These days are cut off point. I realize I talk fast. I covered a lot of material and stuff. But again, if you got the handout, I went into more depth in the handout. I tend to make my handouts more narrative than just PowerPoint slides and that type of thing. So you can actually walk away with it and read it and that type of thing. But again, remember, a lot of this is based on common law, and the common law may be different in your particular jurisdiction. So be real careful whenever you use general observations like that and say that applies specific to our location. When I do stuff for Wisconsin, I always look at Wisconsin case law and Wisconsin statutes, and I support all my stuff in there with that type of stuff. So you can do a lot of search for cases in Google now for court cases. I don't know if anybody's ever done that, but you can specify your state and search for case law for your state for different legal aspects and that type of thing. And that's a good way to kind of get a feel for some of the things that we talked about in general terms or how they're applied in your particular areas. Okay. If there aren't any questions, that's it. If you do have any other questions, feel free to contact me. I'm retired, so I got nothing but time on my hands. Right? So,
hey, Jerry, I got a couple quick questions.
Sure.
One of them, this is slightly off topic from the discussion today, but I'm licensed in Wisconsin. I moved out to Colorado about 2 years ago. And if I wanted to practice in Wisconsin, I can't remember, other than having an LLC in Wisconsin, do you need to physically have an address to practice in Wisconsin?
I don't believe so. Now, in Wisconsin license, did you earn it in Wisconsin or did you get it by
Yes.
reciprocity?
No, I earned my license in Wisconsin. I just got my Colorado license back in March, took the state exam, got the reciprocity, whatever it's called.
So as far as I know, you don't have to have a business address or anything in Wisconsin. You just have to be licensed to practice in Wisconsin. Have to carry a license. A Wisconsin
Great.
license.
Yeah, I got it in 2008, so I practiced in Wisconsin for many years.
Jerry, I'm about 2 weeks behind you. I'm going to retire for the second try in about 2 weeks, but I learned a lot. Thank you.
Yeah. You're welcome. I say retirement's like cooking pasta. If you've ever cooked pasta, you know that it's done when you throw it against the wall and it sticks. Yeah. Generally, the first time you throw it against the wall, it doesn't stick, but the second time it does. That's what retirement was like for me. The first one didn't stick. The second one is though.
Well, that's exactly where I am. My wife's Italian, and we use the refrigerator.
There you go.
Yeah, there's a lot of accolades in here, so well done, Jerry.
Thank you.
Definitely appreciate the presentation. That was awesome.
You're welcome.
Anybody have specific questions that they still wanted to talk to Jerry about? If not, I'll get everything loaded in the Dropbox as well. So, okay. and then Jerry's got it on his website. So,
right. And you got my email address and stuff. Like I say, if you want to ask me anything, feel free to do so.
Fantastic.
Thank you, Jerry.
Thank you, sir. Thank you, guys.
You're welcome.
Thanks, Jerry. That was awesome.
Yeah.
Thanks, Jerry.
Bye, guys.
See you, Trent.
See you guys.
Thank you.